My talk for today will oscillate back and forth between the two fields of fiqh and hadith. It's not my aim to overemphasize the well-known relationship between the two, but I want to examine some early Imami Hadith works from the perspective of their legal relevance. My concern is also historical in that it helps re-establish an earlier case of disagreement between legal scholars. Let me start by drawing on earlier research on this topic. In a paper published in 2001 titled Between Hadith and Fiqh by Robert Gleave, Gleave examines the process at work in the collation of the four main Imami Hadith Compendia, referred to as the four canonical books. Gleave argues that these collections became gradually influenced by an emerging juristic tradition in Imami Shi'ism. Through this process that reflects Imami scholars' preoccupation with legal questions, new techniques of selection, presentation, and organization emerge. Ultimately, these hadith works became a material source upon which jurists could draw in their fiqh discussion, rather than the law itself. The collections of hadith moved into being a genre intended to provide support for the expression of the law delineated in works of fiqh. Gleave examines four literary and formal features in these works, namely the arrangement of the material, the argumentation that corroborates the conclusion, the chains of transmission, and the variations in their wording, so the variants of hadith. In this presentation, I would like to extend Gleave's observation on the relationship that bridges the two disciplines of hadith and fiqh by examining an additional component that is arguably implied in some early works of hadith, namely the depiction of cases of legal disagreement, the depiction of khilāf in these works. I suggest in the following discussion that the legal dispute was a matter that earlier hadith scholars were aware of and attempted to address in their works. Actually, it could be said that this disagreement was inevitable and found its way, although implicitly, to some layers of their hadith works. My examples are taken from Tahdhib al-Ahkam of al-Shaykh al-Ṭūsī and of al-Ḥillī al-Mukhtalaf al-Shiʿi, but the same parallelism that I'm going to show, you can also find it in al-Mu'tabar of al-Muḥaqqiq al-Ḥillī, but the discussion in al-ʿAllāma is larger and more elaborate. So without much theorization, let us first examine the following example for a better understanding of the case I want to show. This is a text from Mukhtalaf al-Shiʿi of al-ʿAllāma al-Ḥillī. The book is dedicated to recording the khilāf among Imami scholars. In this passage, al-ʿAllāma reports on the disagreement of Imami scholars on the matter of using rose water, ma'ul ward, in performing the ritual ablution. He remarks that Ibn Babawayh, Shaykh al-Saduq, allows this practice, while the majority of other Imami scholars did not. He further states that al-Saduq relied on a specific tradition, احتج بخبر يونس, that justifies this ruling. So we have, this is the normal pattern that we find in al-Mukhtalaf. First, that Ibn Babawayh has this opinion, it is permissible to use ma' al-ward. And the mustanad of Ibn Babawayh, what is the proof of Ibn Babawayh? In this case, it is a tradition. And in the cases that I want to show, the proof is always a hadith. Yeah. But there is a problem. So we see our answer, that's the answer coming from al-ʿAllāma. Our answer, the sanad is corrupted. There is a remark on the sanad. And then he quotes al-Shaykh al-Ṭūsī. So he draws on al-Shaykh al-Ṭūsī. So al-ʿAllāma rejects the validity of this tradition through a comment on its sanad, and then refers to a remark that al-Shaykh al-Ṭūsī had made on the same report. Yeah? So here we have a full depiction of khilāf. We know that this scholar adopted this opinion for this reason. We refute this reason for so and so reasons. Okay? By comparing the respective discussion in al-Shaykh al-Ṭūsī's Tahdhib al-Ahkam, so if you go back to Tahdhib al-Ahkam to see the parallel discussion, we find a similar account by which the above-mentioned tradition, the same tradition of al-Saduq, is invalidated, because this is the information coming from al-Ṭūsī also. But here, al-Ṭūsī does not mention explicitly that this tradition is relied on by al-Saduq. So we don't find al-Saduq here mentioned. From this example, we can draw some initial insights. First, al-Ṭūsī was well acquainted with the works of al-Saduq. Here, he is in fact rejecting the latter's ruling and not simply the validity of the tradition. So what he has in mind is the ruling, not simply the tradition. Despite the hadith-based language, something about like the sanad, or like he's saying the hadith is strange, even if you find it transmitted in books. Despite the hadith-based language that frames the discussion, it is the legal question that concerns al-Ṭūsī, even if he does not mention it explicitly. While it's impossible to reconcile this tradition with other reports, there is no way to make a harmony between the contradictory reports here. Al-Ṭūsī doesn't find any way other than completely discarding its validity by referring to some sort of ijma'. So he speaks like, you see that ijma' al-Isābah. That's a technical term, we don't have to go over it. But our respected Imami fellow scholars agreed on neglecting this hadith. By doing so, he invalidates as-Saduq's ruling as well, not only the hadith. What he has in mind again is the ruling itself. In other words, in the background of al-Ṭūsī's discourse, there is a hidden interlocutor whose legal position is at stake. He is speaking with someone. He has someone in mind. Second, while it's possible to argue that al-Ṭūsī's initial plan for his hadith book does not envisage the naming of scholars, maybe that was not his main intention, and he was writing to an audience that could relate. Yeah? The audience, the readers of al-Ṭūsī could know that this position is the opposition of al-Saduq. So while it is possible to argue that al-Ṭūsī's initial plan for this hadith book does not envisage the naming of scholars who adopt the other views, it should be noted, however, that this instance of legal disagreement is attested in one of al-Ṭūsī's legal works, his khilāf, the book al-Khilāf of al-Ṭūsī, which is a book on legal dispute, and again, without naming the scholar who adopts the contradictory ruling. So there is another parallel text in khilāf, and there you find al-Ṭūsī referring to some of our ashab, some of our Imami fellows who adopted this opinion, saying that you are allowed to use ma' al-ward. But again, he does not name who is the scholar. The account of al-Ḥillī, and before him al-Muḥaqqiq, as I said, is more straightforward in reflecting the full image of the dispute by showing that contradictory reports in this matter lead in fact to contradictory rulings among early Imami scholars, whose identities now are well established. In contrast, al-Ṭūsī's account leaves the reader with the impression that the report is an isolated instance, saying that this is a strange, very strange tradition. So one tends to believe that no one has indeed relied on it. Al-Ḥillī seems to be keen to name the scholar who adopted this ruling, to give a name for the scholar. It is as if Al-Ḥillī closes the circle by matching the legal khilāf to its counterpart in hadith. And this by no means is an isolated case in the text of al-Ṭūsī. Further examples can be found in Mukhtalaf, matching parallel discussions in Tahdhīb and Istibsār. That's what I'm going to show. Fourth, now when sources are available, for example, we have now the books of al-Saduq. We can open the book of al-Saduq and see that there is a parallelism. One can say we don't need al-ʿAllāma, for example. When sources are available, we can reconstruct this image by comparing different rulings adopted by Imami scholars. However, al-Ḥillī's reconfiguration of legal dispute in al-Mukhtalaf becomes more relevant from a historical perspective in cases where earlier legal works are not extant anymore. The most important case in this regard is the case of the Imami scholar Abu Ali Muhammad ibn Ahmad ibn al-Junayd al-Iskāfī, whose legal opinions will concern the rest of this talk. Ibn al-Junayd was an influential theologian, linguist, and legal scholar. He flourished at the beginning of the 10th century and was well acquainted with other Imami scholars and figures. He was well connected with Imami scholarly circles, mainly in Iraq and also in Nishapur. He also maintained good relations with the Buyid court, especially the powerful Mu'azz al-Dawla. He authored a large number of legal works, the most important of which are his Tahdhīb al-Shi'a and al-Mukhtasar al-Ahmadi fi al-Fiqh al-Muhammadi. Both works are lost. Ibn al-Junayd's relevance stems from the fact that he was an earlier Imami legal authority whose opinions were criticized and abandoned by Buyid scholars, such as al-Mufid, al-Murtada, and al-Ṭūsī, mainly for his alleged reliance on the reprehensible method of legal analogy, qiyas. Because of this opposition, the legal opinions of Ibn al-Junayd survived only in later quotations, especially in Mukhtalaf al-Shi'a of al-Allāma al-Ḥillī. In his extant works, al-Ṭūsī does not report any legal opinion by name from Ibn al-Junayd, except for the case of forbidding the consumption of fuqa, the brew of beer, or beer. Nonetheless, the extent to which Ibn al-Junayd was known to al-Ṭūsī is greater than this isolated case. And it can be maintained with some confidence that al-Ṭūsī was aware of the distant opinions of Ibn al-Junayd in many legal matters. These pieces of evidence can be found in al-Ṭūsī's legal works, such as al-Mabsūt, Nihaya, and khilāf, but in this presentation I will mention only the examples from his Tahdhīb al-Ahkam. So again, let's see an example. We come back to al-Ḥillī. In this text, al-Ḥillī discusses the proper clothing for women while performing ritual prayers. He remarks that the most renowned opinion, the widely known position for the Imamiyya al-Mashhur, is that women should cover their heads. Wujub satr al-Ras. Ibn al-Junayd had a slightly different position. So you see here, you have the main Shi'i position, the main Imami position, and then al-Ḥillī is reporting, Ibn al-Junayd said, there is no harm for the Muslim free women to perform the prayer without a cover, providing that no one else is seeing her. Al-Ḥillī mentions the view of Ibn al-Junayd along with its scriptural basis. So here we say Ibn al-Junayd argued based on احتج Ibn al-Junayd B. In this case, these are the two reports transmitted by Abdullah ibn Bukayr on the authority of Imam Sadiq. Al-Ḥillī rejects the sanad mainly because of Ibn Bukayr's belonging to the Fatahid group, because Ibn Bukayr was not Imam, he was Fatahi. Despite that Ibn Bukayr was trustworthy. He says like Ibn Bukayr is Fatahi, he is trustworthy, but because he's Fatahi, we reject the sanad of this tradition, because there are other traditions contradicting it. In addition, Al-Ḥillī reinterprets the tradition in a way that brings it into conformity with other reports. And the last hint is borrowed again from al-Ṭūsī's in Tahdhīb al-Ahkam. As expected, if you go to Tahdhīb al-Ahkam, the parallel discussion of al-Ṭūsī does not mention that there is another Imami scholar who relied on these traditions. It simply relegates the two traditions of Ibn Bukayr by reinterpreting them and making them agree with other traditions transmitted by al-Ṭūsī. So if we were reading at-Tahdhīb alone, we will not be able to discern a case of legal disagreement. However, the discussion that is at face value on a hadith, so discussing the sanad, the interpretation, eclipses a legal discussion that is retrievable through the text of al-Ḥillī. And as mentioned, this is not an isolated case. Here are a few examples taken from the first and second volumes of Al-Mukhtalaf. So my examples are from the first and second volume. So these are on purity and prayers. Yeah? So we have in the first volume, in the first column, the theme of the legal case, and then we have the hadith that is at question. And this hadith is usually the mustanad of Ibn al-Junayd, is the argument of Ibn al-Junayd, the basis for Ibn al-Junayd's position. It's usually refuted by al-Ḥillī based on mainly the account of al-Ṭūsī. But there in al-Ṭūsī's text, you don't find a reference to Ibn al-Junayd. Yeah? And these cases are only the cases where Ibn al-Junayd alone is mentioned. Yeah, because there are other cases where we have Ibn al-Junayd and Sayyid al-Murtada, Ibn al-Junayd and Ibn Abi Aqil, for example. Yeah? Just to show to show you how much we have material on like this parallelism, how abundant this parallelism is. Yeah, still in purity, like you see, for example, the tradition here from Sama', who is a Waqifi, so that's why also it gets refuted by both al-Ḥillī and al-Ṭūsī. Yeah? Sometimes you can find a parallel discussion in Mabsūt, for example, or Nihaya or khilāf, but again without naming Ibn al-Junayd. And we will see one example. Yeah. Now to prayers. So, if you want to summarize what is going on, a small phenomenon. You know? The diagram summarizes this observation. As it can be seen, the legal dispute is in almost perfect congruence. It's kind of mirror. Yeah? With the problem of contradictory reports. But al-Ḥillī is clearer in showing the relation between the two. So al-Ḥillī starts by the legal question, saying that we have a legal question Y and legal question X, for example. Legal Y is the position of al-Shaykh al-Ṭūsī, and then you go to the books of al-Shaykh al-Ṭūsī, you find true, this is the position of al-Shaykh al-Ṭūsī, so we can trust al-Ḥillī when he copies text. Yeah? And then when you go here, you find, al-Ṭūsī discussing the same position, but from a hadith perspective. He starts with the hadith, saying we have a hadith A and hadith B. I will adopt Hadith B, and Hadith A, there is a problem with Hadith A. Either it's agreeing with the Amma, agreeing with the Fatahid, agreeing with the... either there's... we can reinterpret the text of this Hadith. We know other Hadiths that are more strong, or that are stronger, yeah? And this discussion here that al-Ṭūsī has is adopted again by al-Ḥillī to refute Ibn al-Junayd. Yeah? Al-Ḥillī does not refute Ibn al-Junayd always, but usually he sides with al-Ṭūsī, just as a remark. In al-Ṭūsī's approach, the contradictory hadith reports are treated with the aim of arriving at the soundest position. The dissent traditions do not develop in his account into legal positions adopted by named scholars. To the contrary, in al-Ḥillī's approach, the contesting views of Imami scholars over centuries are back projected. He's doing a back projection to the status of contradictory hadith reports. A critical remark before we continue. A critical remark is necessary here. We are not sure that these traditions are in fact the ones that Ibn al-Junayd relied on. As al-Ḥillī in his introduction in Mukhtalaf affirms, when a scholar mentions no argument, so he is reporting the disagreement of scholars. If this scholar does not mention an argument, he, al-Ḥillī, will attempt to find one that can support the scholar's position. In the case of Ibn al-Junayd, we cannot always re-establish this case. But also, this is one side of the problem. The other side is that in most cases, the traditions mentioned by al-Ḥillī agree indeed with Ibn al-Junayd's reported position. And also, in many cases, linguistic similarities help ensure that the tradition is indeed in favor of Ibn al-Junayd's position. Sometimes you find the same terminology, sometimes the same order of words. So we are kind of sure that this tradition at least forms a part of Ibn al-Junayd argumentation. Another example. This is a problem related to prayer, to the recitation in prayer. Should it be performed loudly or silently, with jahr or ikhfat? One tradition allows both practices, so you can do both, and Ibn al-Junayd too holds this position. Here, the tradition is transmitted by Ali ibn Ja'far. So again, we have the widely known position of the Imami scholars, then the position of Ibn al-Junayd, and then the mustanad of Ibn al-Junayd, the argument of Ibn al-Junayd. Here it's a tradition. There is a usuli thing, but we are focusing on hadith. There is a transmission from Ali ibn Ja'far, who is the brother of the Imam al-Kadhim, from al-Imam al-Kadhim. And it is perfectly sound in terms of its sanad. So there is nothing wrong in the sanad of this hadith. Al-Ḥillī is saying, Rawa fi sahih. Yeah, so that the sanad of the hadith is fine. But al-Ḥillī, like al-Ṭūsī before, remarks that the tradition on which Ibn al-Junayd relied agrees with the non-Shi'i position, agrees with the Amma. For this reason, it must be neglected and not acted upon. Al-Ḥillī slightly adjusts the rebuttal by suggesting an alternative interpretation of the tradition, saying that what is meant is the al-Jahr al-Ali, the reciting over loudly, if you want. Ibn al-Junayd does not seem also to adopt the tradition in full implication. He recommends not reciting loudly when recitation should be silent or inaudible. So he also does not take the hadith as it is. Yeah? How did he arrive at recommending this? We don't know. But it might be the case that he also knew other traditions relevant to the case. This suggests that he was aware that other relevant reports touch upon this matter. Still, instead of dropping the tradition entirely off like al-Ṭūsī, he chooses to provide a more lenient ruling. Another way to look at the problem is that while al-Ṭūsī's general methodology was to solve the problem of contradictory traditions and bring them into harmony, and we know for sure that he was very disappointed about this phenomenon, Ibn al-Junayd might have taken recourse simply to another solution. The most important remark here, however, is that al-Ṭūsī is arguably silencing the case of disagreement. From Tahdhib, we don't know that other scholars adopted this position. The tradition itself is also refuted altogether. And in his khilāf, if you go to his khilāf, to al-Ṭūsī's khilāf, you will find there that he claims also that there is a consensus among Imamiyya, there is an ijma' on this matter. So he is kind of excluding Ibn al-Junayd altogether. Another example. This is a matter related to ritual purity. So forgive the example. It's on the droppings of certain animals. Are they ritually pure or not? Should one wash his garment from them or not? al-Shaykh al-Ṭūsī has himself two opinions. Yeah, and it's not uncommon to find al-Ṭūsī having two or maybe three opinions. Yeah, al-Ṭūsī has two different opinions on this question. One of them agrees with Ibn al-Junayd's position. Al-ʿAllāma adopts the other position. As shown in the first case, the other position is well known to al-Ṭūsī, but he prefers not to name the scholar who subscribed to it. So, for example, al-ʿAllāma is quoting al-Ṭūsī in Mabsūt, and there in Mabsūt, al-Ṭūsī says, some of our fellow scholars. Doesn't give the name of them. Yeah? We discover that these ashabuna are none other than Ibn al-Junayd. Yeah? In most cases, that's the case. Yeah? And here, I mean, the disagreement, you can see the disagreement is not alarming. He himself is disagreeing with himself. Yeah? So there is no fatahi, there is no ammi, there is nothing. Yeah? Al-ʿAllāma here also, what is important, Al-ʿAllāma invokes a particular terminology, ikhtiyar. So he says, this is the ikhtiyar of Ibn al-Junayd. Choice. The terminology is reported in surviving quotations of Ibn al-Junayd. So we have Ibn al-Junayd saying, akhtaru, so and so. And it's also mentioned in the introduction of Kitab al-Kāfī, but we can discuss this later. Back to the case, Al-ʿAllāma remarks that both positions are attested in hadith. So both positions have their roots in hadith. And that many traditions indeed speak for Ibn al-Junayd's position. So you see, they argued based on many traditions. One of them is the tradition of Muhammad bin Muslim. Al-ʿAllāma, however, opted for the reconciliation scheme. He wanted to do the jama' bayn al-akhbar. When we can make the traditions agree, it's better. Yeah? Suggesting also a reinterpretation of Ibn al-Junayd's tradition. It should be remembered, however, that we are seeing the scenery from Al-ʿAllāma's perspective, which is pretty much the same perspective of al-Ṭūsī. However, if we were to suppose that Ibn al-Junayd was aware of the presence of many traditions relevant to this question, and we know that he knew about the problem of contradictory traditions, we might suggest that he opted to choose from among them instead of insisting on reconciling them. Yeah, so Ibn al-Junayd was seeing the same problem, that we have many traditions, and one group is arguing for one position and one group is arguing for the other. Instead of insisting to bring the two groups into harmony, he simply said, like, I choose one of them. Yeah? He had another solution, so to speak. The case is reminiscent of al-Shaykh al-Mufid criticism of Ibn al-Junayd on this point, namely that Ibn al-Junayd failed to harmonize the traditions that bear apparent contradictions. So we have in al-Mufid before al-Ṭūsī criticizing Ibn al-Junayd in his al-Masā'il al-Sarawiyya, precisely for Ibn al-Junayd was not able to harmonize the traditions. Yeah, I will not read everything, but like he said, like Ibn al-Junayd thought that the traditions were contradictory in meaning. وظن أنها مختلفة في معانيها. Al-Mufid refuted this in one of his works. Yeah, and the main achievement of Mufid was to harmonize their meaning, to harmonize the meaning of the hadith. وَجَمَعْتُ بَيْنَ مَعَانِيهَا. So there is no contradiction anymore. The final example for today is a case on performing prayers while traveling to another land, Salat al-Musafir. The question is how many days one should stay at the destination in order to perform full prayers and attend Friday prayers. The known position is 10 days. Ibn al-Junayd has an opinion, 5 days. Yeah? Al-ʿAllāma seems to waive the discussion on the sanad. He says, I'm not going to discuss the sanad. But he remarks that the tradition that supports Ibn al-Junayd's position does not consider other similar transmissions that al-Shaykh al-Ṭūsī records. So there is a problem of comprehensiveness, so to speak. Yeah? By combining different reports together, al-ʿAllāma and al-Ṭūsī before him suggest, for instance, that this tradition, that is the proof of Ibn al-Junayd, is only valid in Mecca and Medina. So there is another variant of the tradition, possibly Ibn al-Junayd was not aware of, that says that this 5 days thing is only valid in Mecca and Medina. And it's also transmitted by the same transmitter, Muhammad bin Muslim. Al-Ḥillī follows al-Ṭūsī and rejects therefore the legal position of Ibn al-Junayd. However, al-Ḥillī seems to allow a space for disagreement on behalf of Ibn al-Junayd. He is relaxed to treat the khilāf. And he alludes to the possibility of interpreting the tradition as a sort of recommendation, of istihbab. This, what al-Ḥillī is doing, the interesting thing is that he is not marginalizing the position of Ibn al-Junayd completely. Yeah? al-Shaykh al-Ṭūsī in Tahdhib does not mention that another scholar relied on this tradition. The information is only retrievable through al-Ḥillāma's mukhtalaf. Put differently, had it not been for al-Ḥillāma, we would have never thought of the tradition as the basis of an actual legal position by a specific legal scholar. As we have seen, three main problems emerge in the traditions that Ibn al-Junayd is said to have relied on. First, it might be the case that the sanad, from the point of view of al-Ḥillāma and al-Ṭūsī, that the sanad is sometimes corrupted or weak compared to other reports. Here, to some extent, the presence of non-Imami transmitters is signaled out, mainly Fatahid and Waqifid. We don't have to exaggerate on this, but there are many cases where, because of the transmission is transmitted from a Waqifi or a Fatahi, it is refuted by al-Ḥillāma, but Ibn al-Junayd seems to have no problem in this. And it is hard to think that Ibn al-Junayd was unaware of this. For instance, he was a student of Humayd bin Ziyad, a renowned Waqifid scholar of Kufa. The resemblance between Ibn al-Junayd's positions and other non-Imami transmitters might have been very sensitive for scholars like Mufid and al-Ṭūsī, especially if they were able to find Imami traditions that contradict those positions. To this, one should add, however, that if we accept that Ibn al-Junayd relied on these traditions, in fact, we still don't know the exact sanad through which he got acquainted with the hadith. In most cases, in mukhtalaf, the tradition is reported with the sanad of al-Ṭūsī. Yeah, so al-Ḥillāma is criticizing the sanad of Ibn al-Junayd, but using the sanad of al-Ṭūsī. Second, it might be that the tradition is that the tradition in favor of Ibn al-Junayd agrees with the non-Imami or the non-Shi'i position, al-ʿAmmah, and this is a known problem. Therefore, al-Ṭūsī and al-Ḥillāma affirm that the Imam must have uttered the tradition in a state of dissimulation, of taqiyya. That's the usual way to go out. Here we can also assume that Ibn al-Junayd knew this fact, knew that his position aligned with non-Imami or with the non-Imami groups. But apparently he seems to be indifferent on this point. Yeah. Third, as al-Ḥillāma suggests, when combined with other traditions, another interpretation can be attained, and the apparent disagreement is solved. That's the being comprehensive, the problem of being comprehensive. However, we don't know whether Ibn al-Junayd knew the other traditions transmitted by al-Ṭūsī and discussed by al-Ḥillāma. He might have been aware of the status of contradiction, so he knew that there are many reports on the case, but what he knew precisely cannot always be retrieved. From a historical perspective, al-Ṭūsī's discussion of contradictory traditions blurs the legal scene at that time. And I'm not accusing al-Ṭūsī of this. He was writing for his audience, as I said, and he was not expecting that we'll come here in Birmingham and discuss his books. And by the legal scene, I mean the theoretical positions and the actual practices too. This is especially true in the cases where we don't have the books of these scholars anymore. So mukhtalaf does not only preserve the legal disagreement of earlier scholars, but also allows for a partial reconstruction of that legal scene. To conclude, the above-mentioned observations can be discussed from various points of view. I want to conclude by organizing these thoughts in 4 different directions, showing the relevance of these abundant examples of intertextuality between legal works and Hadith Compendia. And in doing so, I wish to ask more questions than providing ready answers. What concerns Ibn al-Junayd? It's clear that Ibn al-Junayd's legal positions are rooted in Hadith reports. Whether these are the traditions he relied on or not, the least that can be said is that his law is entrenched in Hadith. In this, surprisingly, he's closer to the methods and style of al-Ṭūsī. More than it is usually imagined, his legal discussion resembles that of al-Ṭūsī. You are reading the same argument of al-Ṭūsī, but with different material, with different component. Although the latter, or al-Ṭūsī, was better positioned, arguably, to have an elaborate accounts. He was able to gather more traditions, for example. Having said this, we can conclude that the accusation of qiyas is therefore a little bit exaggerated. Yeah? But this is a story for maybe the Q&As or for another time. What concerns al-Shaykh al-Ṭūsī, the straightforward observation is that the space allowed for legal disagreement in the work of Ṭūsī is very limited. And like the scholar, the khilāf, when it is revealed, refers to nameless scholars. Yeah? The main project of al-Ṭūsī was arguably eliminating this dispute by solving the problem of contradictory reports. His hadith works are attentive to the legal implications of this problem, and this was indeed the aim of the book, to relieve the legal dispute and not simply reconciling the contradictory traditions. Al-Ṭūsī was defending a specific understanding of law that was not shared by other scholars, such as Ibn al-Mufid. We tend to read Al-Ṭūsī's Tahdhīb as performing a monologue. He's speaking to himself, just a commentary on al-Mufid's Muqni'a. However, the many examples brought to light by al-Ḥillī and Mukhtalaf suggest a more dynamic depiction of this work. There is a dialogue with these nameless scholars. Therefore, it's tempting to readdress Tahdhīb, and for that matter, for example, al-Istibsar, from a different angle. My concern is history, for example. The questions that I have for future research maybe, can we find any common feature that combines all traditions refuted by al-Ṭūsī? So if you take all the traditions that al-Ṭūsī doesn't like, is there anything common between them? Is there one spirit that combines these traditions? Can we find an implicit reasoning that governs the arguments of al-Ṭūsī in these cases? From the examples shown above, is it possible to discern, for instance, a consistent elimination of Waqifi and Fatahi elements from what was thought to be the original Imami legal position, especially when non-Imami positions are contradicted by Imami traditions? Another question is, for example, in the case, like we had this case from Abdullah ibn Bukayr, can we make a transition from hadith to legal practice? So can we say, for example, that the Waqifi women used to do the prayer without the cover on their heads? But also this is a question for later time. The differences between Shi'i groups in this regard should not be exaggerated again. However, the historical relevance of these cases should not be underestimated too. A critical study might suggest where, when, and with whom, with which transmitters, Shi'i groups started to adopt distinct legal positions. What concerns al-Ḥillī, al-Ḥillī's treatment of the problem of legal disagreement is, I hope it's clear now, is more moderate and relaxed in comparison to al-Shaykh al-Ṭūsī, for example. He is more comfortable exhibiting these differences and discussing them, although he sides always, or in most cases, with al-Ṭūsī. And also the important thing is that by doing so, he normalizes the legal disagreement of Ibn al-Junayd. In fact, he reintegrates Ibn al-Junayd in the legal discourse as an early Imami legal authority whose views ought to be addressed appropriately. I should conclude from where I started, fiqh and hadith. What I wanted to show is that in early hadith works, we can identify a legal layer that is significant in its normative and historical relevance. By re-examining these hadith works from this perspective, we are in a better position to put the development of legal thinking in its appropriate historical context. Thank you.